afternoon, everyone. I'm Ryan Costa from the Delaware chapter, and it's my pleasure now to introduce our second panel for the day. This panel will be on the regulation of big tech. With us we have, I'm just going to do a quick introduction of our panelists, and then I'm going to turn it over to them. So at the far end, we have Professor Joshua Wright. Professor Wright is a university professor of law and the executive director of the Global Antitrust Institute at Scalia Law School at George Mason University. Professor Wright also holds a courtesy appointment in the Department of Economics. In 2013, the Senate unanimously confirmed Professor Wright as a member of the Federal Trade Commission following his nomination by President Obama. He is also a leading scholar in antitrust law, economics, intellectual property, and consumer protection, and has published more than 100 articles and book chapters, co-authored a leading antitrust book, and edited several book volumes. He was awarded the Paul M. Batter Award by the Federalist Society in 2014 to an academic who demonstrated excellence in legal scholarship, a commitment to teaching, a concern for students, and who has made a significant public impact. Next to him is Taylor Owings. Ms. Owings is counsel to the Assistant Attorney General for the U.S. Department of Justice. She serves as a liaison to the Technology and Finance section, the Civil section of the San Francisco office, the Appellate section, and the Competition Policy and Advocacy section. She joined the DOJ's Antitrust Division from private practice in the San Francisco office of an international law firm, where she advised tech clients on the application of antitrust law to high-tech business models. Ms. Owings also clerked on the U.S. Court of Appeals for the D.C. Circuit for the Honorable Douglas H. Ginsburg, and on the U.S. District Court for the District of Columbia for the Honorable Richard J. Leon. Next to her is seated Barry Lynn. Barry Lynn is the executive director of the Open Markets Institute. The goal of the Open Markets Institute is to use journalism to promote greater awareness of the political and economic dangers of monopolization, identify the changes in policy and law that clear the way for such consolidation, and foster discussions with policymakers and citizens as to how to update America's traditional economic principles for our 21st century digital society. Before establishing the Open Markets Institute, he spent 15 years at the New America Foundation researching and writing about monopoly power. He is the author of Corner, The New Monopoly Capitalism and the Economics of Destruction, as well as End of the Line, The Rise and Coming Fall of the Global Corporation. And finally, our moderator for this panel is the Honorable Stephanos Bibas. I'm not going to spend any time retreading his extensive credentials that we just heard from Mr. McGann, but instead we'll turn it over to you.
Thank you, Mr. Costa, and thank you all for coming here. So in 2002, the Department of Justice entered into a consent decree with Microsoft. At that time, Microsoft had about more than 95% of the market share in internet browsers. Since then, we've seen a new generation of tech giants take the stage, companies like Amazon, Apple, Facebook, and Google. In the 15 years since it was founded, Facebook has captured about 73% of the global social media market, if you define the market that way. And 88% of online searches worldwide occur on Google. Domestically, Amazon has captured roughly 38% of the US online retail market, if we think of it as a distinct market. And Apple leads the US smartphone market with a 41% share. The growth has led to investigations by the US Department of Justice, the Federal Trade Commission, and a number of state attorneys general. And all of these investigations raise the following question that we're going to focus on today. What is the proper role of government in response to big tech? And to address this question, we have a very distinguished panel with us. We're going to start with Taylor Owings, counsel to the Assistant Attorney General for the Department of Justice's Antitrust Division. We'll then go to Barry Lynn, who's the Executive Director of the Open Markets Institute, and then to Professor Joshua Wright. You've already heard he's a former commissioner of the FTC. He's a professor of law and global director of the Global Antitrust Institute at the George Mason University Antonin Scalia Law School. So let's start with Ms. Owings.
Hi there, thanks so much for having me, and thanks to the Federalist Society for putting on this event. I work for the government currently, and so I view my role on this panel as being to sort of set the stage about what the law is currently, and to provide some perspective about what me and the Antitrust Division, the enforcers of the federal antitrust laws, are thinking about and currently see as the landscape of precedent and the bounds of federal antitrust laws as they exist today. So in service of that goal, I think it helps to kind of set out a broad background for what the federal antitrust laws are really trying to accomplish as written into law today. So the underpinning of the federal antitrust laws is that consumers benefit when there is competition. So when there's choice between different firms in a market, then consumers can exercise their choice and reward the competitor that is serving it best by doing a transaction with that competitor. So the idea is that consumer welfare or consumer benefit from a transaction is going to be increased by there being a well-functioning competition in a market. This concept of consumer welfare is really, it's something that we are talking about a lot in the popular media today, and I think what's important to keep in mind is that there is sometimes a misconception about what the federal antitrust laws are currently designed to do. It's not necessarily to protect consumer welfare at all costs. It's to protect consumer welfare through the means of the competitive process. So there are a couple of different ways that the federal antitrust laws set out to do this. One is through the Sherman Act, which prohibits anti-competitive agreements between companies, and also prevents monopolization, which is, of course, I think, you could see it as the focus, perhaps, of today's panel, because the concept of monopolization is that when a company has market power or dominance, that it has to compete on the merits, not by harming the competitive process and preventing other competitors from entering the market and entering the market or gaining market share on the merits. And then also there's the Clayton Act, which prevents anti-competitive mergers, which you also see some discussion about in the media today about whether the large tech companies have accomplished any anti-competitive mergers. So that's the basic outline of the federal antitrust laws as they exist today, and I'll focus a little bit on Section 2 of the Sherman Act, which prevents monopolization, because again, I think that's largely the focus of sort of popular dialogue when it comes to the big tech companies. So Section 2 has two elements that have to be satisfied. A plaintiff in a Section 2 case has to demonstrate that the defendant possessed monopoly power in the relevant market and that it willfully acquired or maintained that monopoly power through exclusionary conduct. So these are very much terms of art, that there's enormous amounts of precedent explaining what these various elements mean, but it's very much still an open topic of debate what constitutes exclusionary conduct by a firm with market power. One of the best guides that we have to what exclusionary conduct is and constitutes is the Microsoft case out of the DC Circuit in 2001. So there the DC Circuit explained that to be condemned as exclusionary, a monopolist's act must have anti-competitive effect. That is, it must harm the competitive process and thereby consumers. In contrast, harm to one or more competitors will not suffice. The Sherman Act directs itself not against conduct which is competitive, even severely so, but against conduct which unfairly tends to destroy competition itself. The court goes on to explain that it can often be confusing to distinguish between vigorous competitive conduct and conduct that is actually exclusionary. It quoted the U.S. Supreme Court case Trinco, saying that to safeguard the incentive to innovate, the possession of monopoly power will not be found unlawful unless it is accompanied by an element of anti-competitive conduct. So this is really the common misconception that I was referring to earlier. There's a difference between a firm being dominant and using that dominance to affect or diminish consumer welfare. And by that you might think of a company charging a monopoly price, elevating price because it has no competition. And then on the other hand, using dominance in a way that harms competition or the competitive process. So for instance, a classic and sort of funny example, one might think, is if a dominant competitor lights its rival's factory on fire. That is not competing on the merits. That is that's not harming consumers directly. That is potentially harming the competitive process because it's excluding a competitor from the market. There's one way to think about the common misconception that can come up in this debate is in contrasting the U.S. system against foreign competition law regimes. And one example of this is the German Federal Cartel Office decision in 2019 finding that Facebook was dominant in the market for social networks and that its data collection practices violated European data protection laws by combining information gathered from non-Facebook platforms into Facebook's data profile on the individual user. The cartel office in Germany found that Facebook was able to get users to agree to the combination of data like this through take it or leave it terms that amounted to what is a term of art there, exploitative abuse of dominance that Facebook enjoys in social networks. The FCO, the German Federal Cartel Office, also found that amassing data in this way gave Facebook even more market power because it would optimize its own service based on this improved data that they received and improved user profiles. So I think this example is illustrative of a difference between American antitrust law and European antitrust law, in that the basic mechanism by which the German Federal Cartel Office was alleging a problem here was by saying that Facebook was actually making its product better. It used potentially suspect means, but it was making its product better by amassing more data. This is not a concept that we have in American antitrust law. We don't have a concept of exploitative abuse being itself unlawful. If a company exploits its monopoly power to then harm competition and not compete on the merits through an improved product, that would satisfy a Section 2 claim. But this concept of merely using the power to harm consumers straight away through exploitative abuse is not a cognizable concept in U.S. antitrust law. I think it's also helpful to offer some perspective on the potential remedies that are available in a Section 2 case. I feel like often in the public debate, there's a little bit of putting the cart before the horse. A lot of people will talk about the desired outcome of an antitrust enforcement action before really talking about the process by which you get there. So we are we being the Antitrust Division, and I'll go ahead and lump the Federal Trade Commission into this too, by virtue of them being another antitrust enforcer. We are law enforcers first, not regulators. We prove elements of a case, and then we seek a remedy that addresses the harms to competition that have already occurred. I think it's worth noting that, again, putting in perspective the U.S. system versus international systems, there have been some somewhat concerning calls internationally to kind of reverse this system, to use more intervention prior to proving the elements of a case, and really going back after a intervention is imposed and proving up the elements of the antitrust case afterwards. This is not the system that we use here, and I think that's thankful, or I think we should be thankful for that, because one of the real insights that we've gained in the past 50 years in the practice of antitrust law, through the use of economics to be rigorous in our understanding of what the effects of certain company behaviors are, is that over-enforcement has as much harm, can do as much harm to competitors as under-enforcement. And that's because, as I was quoting from the Supreme Court earlier, vigorous competition can sometimes look concerning, but it's actually to the benefit of consumers to have companies vying to out-innovate one another, be more attentive to consumer preferences. And so the concept of putting the cart before the horse, having the remedy determined before the elements of a Section 2 claim are established is alarming. It's an alarming trend, I would say, in the current debate about what the right thing to do is in a world where we see more consolidation in digital markets. So going back to sort of the proper way of thinking about remedies under Section 2 law, if the plaintiff, if the antitrust enforcer shows harm in the liability phase, that specific harm should yield a remedies phase in which the court would have equally a searching look at the likely competitive effects of any remedy that would be imposed, whether it be breaking up a company, imposing contractual licensing terms, creating an obligation to make data interoperable or portable, something like that. A real assessment of what the competitive effects of that remedy would be are an important step in the judicial process. The court really, the reason that it's so important to engage in this separate remedies phase is that, especially in a Section 2 case, there's a lot of factual complexity to try to figure out a but-for world. What would happen under extremely complex market conditions if you changed a couple of the terms by which competitors compete. Unlike in a merger case where you can stop the harmful merger before it is consummated, in a Section 2 case, you would be alleging some harm to the market has already occurred, competition has already been harmed, and the court is in the position of having to design a remedy that would undo that rather than prevent it in the first place. And that's a seriously difficult and complex exercise. I believe that I am supposed to keep my remarks short here, so I feel like that is a pretty good overview of Section 2 law and federal antitrust law as it exists today, and I'm sure lively debate will ensue on other topics afterward.
Thank you, Ms. Owings. Mr. Lynn.
No, thank you, and it's a great time to be sort of sitting in a room like this, debating antitrust, anti-monopoly. It's 10 years ago, I mean, there was a lot of rooms like this. It just wasn't nearly as pertinent to what was going on out in the world. I think that I'll start off with some framing, which we'll be able to perhaps come back to and use later in the debate. I think it's where we are now in this. It's actually worth going back and sort of looking at some of the first principles, some of the first statements, so actually in this case, maybe I'll start with a couple of quotes from Senator John Sherman. He gave a speech in 1890 around the time that he was promoting his bill in the Senate. And the first quote is one that you probably have heard. It's one of the most famous quotes in American democracy. And what Sherman said is, if we will not endure a king as a political power, we should not endure a king over the production, transportation, and sale of any of the necessities of life. If we would not submit to an emperor, we should not submit to an autocrat of trade, with power to prevent competition and to fix the price of any commodity. The second quote is equally important because it begins to explain how to address such power, and it also provides another reason about why it is necessary to do so. This is the quote. It is the right of every man to work, labor, and produce in any lawful vocation, and to transport his production on equal terms and conditions and under like circumstances. This is industrial liberty, and it lies at the foundation of the equality of all rights and privileges. I'm going to make two basic points today. The first point is that the danger we face today from the concentration of economic power and control is in many respects greater than what Americans faced at the time that Senator Sherman introduced and defended his bill. This is true widely in our political economy. We've seen extreme concentration across the political economy in just about every sector over the last 30 years. It's especially true in the case of big tech. Google, Facebook, and Amazon each pose a variety of direct and imminent threats to our democratic institutions, to fundamental individual liberties, and to the stability and vibrancy of our economic system. The second point is that we have all of the intellectual and legal tools we need to address this problem, and indeed we know exactly what we need to do. The basic fix has long been fundamental to the American tradition of anti-monopoly enforcement. Indeed, we saw it right in Senator Sherman's second quote. So maybe, I had a section in here about, where are we in antitrust today? I think we'll sort of get to that in the back and forth later. So I'm just going to jump ahead to, sort of a little discussion about what are the platforms, what are Google, Facebook, and Amazon? Because we know these corporations are remarkably complex conglomerates. Google controls multiple key online platforms, including search, maps, email, Android, Chrome, YouTube, DoubleClick, many others, also like a growing suite of other technologies and businesses. Amazon, for instance, they've invested scores of billions of dollars in warehouses and distribution hubs and transportation systems and robotics technologies and manufacturing relationships. They have their cloud computing service business. Then they also, of course, have their core e-commerce platform. Our team and a few others have for years held that Google, Facebook, and Amazon already had captured control over a great array of markets and the people who depend on those markets to buy and sell certain goods and services. Until recently, a lot of folks on the more conservative side of the discussion have held that Google, Facebook, and Amazon are businesses that exist mainly within markets, hence are regulated by the need to compete with other corporations offering similar services. As you know, this has begun to change. It's not finished changing, but it's begun to change. In the past, Americans applied some form of common carriage law to any network or monopoly provider of an essential service or good. Common carriage, of course, means requiring that the monopoly provider treat every customer the same and that they charge every user the same price for the same basic service. Americans have traditionally allowed some discrimination based on the class or type of a particular good or service, as long as such discriminations are approved and audited by the public. But under common carriage regimes, there must be no first-degree or personalized discrimination in pricing or terms. This is a very ancient rule. It goes back to the monopoly of parliaments in 1623. Because without this rule, you do not have protection of personal private property and you do not have rule of law. Today, however, although Google, Facebook, and Amazon have each monopolized the provision of multiple essential services, neither federal nor state anti-monopoly enforcers treat them as common carriers. As a result, these three corporations enjoy a de facto license to discriminate in how they treat each individual seller and supplier and how they treat each individual buyer. So, a couple words on how these corporations make money. What are their business models? As I noted, these corporations are remarkably complex conglomerates. At bottom, however, the way they make money is pretty simple. These three corporations have developed business models that depend on their ability to combine this license to discriminate in how they serve different sellers and different buyers. They combine that with their monopoly control over certain essential goods and services and with the knowledge that they have developed about the interests, habits, and business models of the sellers and buyers who use these platforms, who depend on these platforms. That said, these three corporations do differ somewhat in how they turn this combination into cash. What Google and Facebook do is they sell advertising. They sell a lot of it. Last year, Google took in $116 billion, almost all of that from advertising. Facebook, $55 billion. And these figures are going up fast as advertising swiftly shifts from other media to the internet, and as these two corporations swiftly monopolize an ever greater share of that online advertising. These two corporations captured control over advertising by building the world's most powerful manipulation systems. They design their systems to manipulate where you go, what you buy, what you watch, what you read, how you vote, even how you think. They then rent out these manipulation machines to whoever will pay them, just about. It could be Procter & Gamble. That could be Vladimir Putin or someone working for him. Amazon, by contrast, makes most of its money by manipulating the interaction between buyers and sellers and then charging sellers fees for different types of fulfillment services. This can include listing their products on its website, storing them in its warehouses, shipping them to the customer. Increasingly, Amazon also charges fees to buyers. Over the last 2 years, Amazon has also begun to earn a lot from advertising. Under traditional anti-monopoly law, such individualized pricing for access to a vital good or service was viewed as highly destructive of economic, social, and political balances. Corporations that exploited their control over the gate to the market to extract the maximum amount of money possible from a particular customer for a particular service were believed to be engaging in a form of extortion. Corporations that control the gate to the market and that enjoy a license to engage in discriminatory pricing also use their power not only to extort money, but also to extort political favor. Most often, this political favor takes the simple form of requiring that the victims of such use of power do not speak in public about the act of extortion itself, or it will be made worse. Google, Facebook, and Amazon did not invent this business model. It has been used many times in the past, most systematically by railroads in the period before the passage of the Interstate Commerce Act. What these three corporations have done is simply to update the business model for the era of the internet platform and masked caches of data, of secrets. The immediate threat, we'll come back to this later, but there's a number of immediate threats that are posed by this structure, this corporate structure, the structure of power. These include a fast-growing array of economic threats to the people of the United States. This includes the choking off of entrepreneurship and innovation across a wide range of business sectors, ranging from manufacturing to retail to transportation to the structure of the internet to the nature of the applications designed to operate on the internet. It includes the concentration of risk in a wide and growing array of complex systems. We can talk more about that in detail later if you want. My first book was all about the ways concentration of power makes systems unstable. All of these incredibly important and pressing effects, however, pale in comparison with a wide and growing array of immediate political dangers posed by these three corporations. The rapid choke pointing of control by Google, Facebook, and Amazon over the flow of information and commerce in our society poses what is perhaps the gravest set of threats to American democracy and individual liberty in at least a century. We could just go down a list. Misinformation and propaganda, the warping of debate in our society, the starving of journalism, the censorship of traditional media. This is all because of this system of these systems of manipulation they have built and the way they use them. There's some testimony that was that I did presented last week that was distributed perhaps is available on the website here. There's a story in there about what Facebook did to Wired magazine. You should read that. You should understand how they censor people for saying things in public that they don't like. The pyramiding of political power. Pyramiding of political power is when you get very powerful people, very powerful actors who become afraid of you because you got more powerful than they are. We now see a concentration of power in three super regulators in our society. And there's a whole bunch of people who are now becoming afraid to speak out against that. In recent weeks, Americans have learned that many large U.S. corporations now censor their speech and actions out of fear of retribution by the Chinese government. As we've seen, this includes the National Basketball Association, and Disney, and Apple, and Marriott, and Nike. To protect their access to the Chinese market, these corporations willingly repeat Chinese state propaganda. They alter maps of East Asia. They suppress certain news and information. They promote Chinese political aims to the U.S. government in Washington. The same is increasingly true also for the fast-growing number of corporations that fear Google, Facebook, and Amazon. For the same reasons that a growing number of powerful corporations toe Beijing's line, a growing number toe Silicon Valley's political line. So we're going to have time to talk about next steps, but as Taylor mentioned, antitrust is in a period of radical change. There are now two very different antitrust philosophies that are in competition with one another in the United States and around the world. Taylor gave you a good introduction to one of them. I want to just give you a couple words about the first philosophy of anti-monopoly, which was the one that dates to the founding. It dates to the Tea Party rebellion against the British East India Company's monopoly over trade. It dates to the 1623 Parliament of Monopolies and the effort to bring the king under the control of the people and establish rule of law. A main goal of this original anti-monopoly philosophy is to protect the liberty of the citizen to sell goods or services on an open market without any regulation by any intermediary. A second main goal was to protect democratic institutions and balances from dangerous concentrations of power and control. This traditional philosophy of anti-monopoly is constitutional in nature. It is essentially an effort to extend the system of checks and balances from the political system into the political economy. If we're not using anti-monopoly in that way, we do not have liberty, we do not have democracy, we have autocracy. We see autocracy rising in our society as we sit here. So anyway, I look forward to the debate. Thank you.
All right. Thank you, Mr. Lynn. Professor Wright.
Thank you very much, Judge Bibas, Barry, Taylor. It's an honor to be on the panel with each of you. Barry and I especially get to do this dance from time to time together, and I believe my role in the dance is to disagree, so I'm going to get right to it. So I'm going to talk about a couple of different things. One is to give a little bit more perspective on how I think Taylor did a wonderful job setting out current doctrine, in particular Section 2 monopolization law. But I think it is worth, sort of with the goal of teeing up a conversation about the sort of current fight in antitrust about whether where we are is doing the job and whether we ought to go somewhere else. I think it's maybe worth a stop to think about why it is we got where we are, and maybe to put some meat on the bones of some of the proposals to change that. So a couple of things. So one, Bear started with the history of the antitrust laws, and I agree it is worthwhile to think about what some of that history looks like, but in large part from 1890 well through the 1960s in this country, the antitrust laws sort of settled on a vision that is related to the one that Barry has in mind for the new antitrust laws. The antitrust laws did more than just do the consumer welfare standard that Taylor described. The antitrust laws, if you were to sort of draw out decisions from the 1890s through the 1960s, had the antitrust laws doing all sorts of things. Had the antitrust laws protecting small business, protecting consumers, protecting particular industries, protecting one industry over another in conflicting ways in a variety of cases. The antitrust laws were the protectors of small dealers and worthy men, of the integrity of mankind, of climate change, and a couple of other things. And so the cases sort of flowed around from 1890s to the 1960s, and the Supreme Court in a series of cases starting in the late 70s says, this isn't working. In a bunch of unanimous and supermajority decisions, the Supreme Court in cases joined by Justice Scalia and Ruth Bader Ginsburg, come back and revisit the antitrust laws and say, let's just do the consumer welfare thing. Let's do that. We know how to do that. Let's do that. Why? If you look at that same bunch of decisions, the types of things that emerge, a horizontal merger between firms with a total of 4% of the market, illegal. Vertical mergers, illegal. Think of something else right now, illegal. All of it. Virtually anything other than a spot contract trade where you hand $5 over to the barista for a cup of coffee was almost certainly illegal and probably a felony, although the nice folks at the DOJ might not prosecute out of prosecutorial discretion. Now, that state of affairs led to disruption in antitrust that ultimately led to Robert Bork's antitrust paradox, influenced the Supreme Court along with a lot of other things going on at the same time, probably sort of beyond the scope of what we want to talk here, but including a lot of changes in the understanding in economics. One of the most important changes in economic thinking at the time was the idea that competition and concentration were not the same thing. Right? Antitrust law, previously, the idea was if I wanted to have merger policy, is a merger between two firms in an industry that have 6 firms in the industry, and now it has 5, and I can do antitrust with my fingers because 5 is bad and 6 is better, because concentration and competition were thought to be the same thing. We learned pretty quickly when economists started studying the relationship between competition and market concentration that markets were, surprise, pretty complicated places. And if we were able to, it should surprise you if we could, counting the number of firms with our fingers, predict market prices. Turns out we can't, right? Universal agreement among industrial organization economists, left, right, and center, that counting market share and the number of firms in an industry isn't a really good way to predict what ultimately happens to consumers. In those markets, the reason why this really matters ties back to a proposition Taylor started with, right? So what are modern antitrust laws attempting to do? They are attempting to harness the power of competition to the benefit of consumers. Right? We often in antitrust laws articulate that through the lens of this consumer welfare standard. Right? So what stuff does the consumer welfare standard prohibit? Things that allow the acquisition or deployment of monopoly power that make consumers worse off. Right? So it is important to figure out what is going on in these markets. a key feature of United States antitrust law that emerged from this sort of revolution in the doctrine, away from having 6 masters instead of serving one, the consumer welfare standard, and leaving other bodies of law to handle things like protection of small businesses or other socioeconomic interests that might be very important, but were decided to keep sort of outside of the scope of the antitrust laws. One of the important features of modern doctrine, Section 2 of the Sherman Act, is in the United States, and this is, I think, whether it is a bug or a feature of American antitrust law will depend on your perspective, but to me, no doubt it is a feature, that competition that results, if I out-innovate you and I'm the last man standing in the market because I make a better product, right? I'm allowed to do that here. If I do that here and I am able to charge the monopoly price because of that, that is not a violation of the antitrust laws. In opinion after opinion, the Supreme Court says that form of competition, dynamic competition, not the competition that arises because I've got 100 firms, or the type of competition that arises because I have more firms than fewer, but it's competition to be the firm, right? It's competition to, excuse me, it is competition for the market rather than sort of just within the market. The U.S. antitrust laws take a pretty clear stance that we want to encourage that type of competition here. That is not true. My institute, the Global Antitrust Institute, most of what I spend my time doing is flying around the world and teaching economics and antitrust to judges and regulators there are now 130 jurisdictions with antitrust laws. And 70 of them have adopted them in the last 20 or so years. They want to know what they're doing, right? And the battle in most of these countries is we want a system like the American system that sort of values dynamic competition, or some alternative that looks much more like a system that focuses only on static competition. We have sort of simple rules, we count the number of firms with our fingers, we make presumptions about market shares, and sort of off-run our prohibitions and obligations under the antitrust laws. Our system's largely rejected that. I don't think the idea that there is a significantly greater amount of innovation here is an accident. It's certainly also not solely attributable to the antitrust laws. But I think that is an important feature of our system, and one that really lies at the core of some of the differences between the worldview of antitrust, I think embodied by current doctrine, and the one I support, and perhaps the one that Barry envisions. The last thing I will say is to talk about the limits that have emerged in current antitrust doctrine as opposed to some of the proposals floating around for what we might do. I certainly agree with what Barry said, that this is certainly during my antitrust career the most interesting time in a very long time for a variety of reasons, but I think it's worth sort of being less abstract and more specific about what some of the proposals are. So under Section 2 of the Sherman Act currently, one of the unifying themes of Section 2 doctrine is that the plaintiff bears the burden of proof to show that particular conduct has an anti-competitive effect. You do not get to win an antitrust case under American antitrust law under Section 2, Section 1, or Clayton Act Section 7 by walking into the room and having a theory about why conduct resulted in harm to consumers. Most conduct that is pro-competitive makes the rival worse off. Most conduct that's anti-competitive makes the rival worse off. It is really hard to look at the outcome for the rival and make inferences about how well consumers are doing. U.S. courts responded to this by saying, the big important thing that we're going to do in antitrust cases, the core burden a plaintiff will face in Section 2, is to demonstrate anti-competitive effect. Anybody can have a theory. You've got to put your money where your mouth is and come have proof of harm. That's the structure of American antitrust law. It has been for a very long time. So to the extent any of these, I think I counted a list of 6 names of firms. My economic textbook makes me feel some tension at calling them all monopolists at the same time, but we'll leave that for Barry to answer for. But if he's right, and if they've all got monopoly power and they can prove harm to competition, current doctrine is built for that. That DOJ Microsoft case that Taylor said, if I recall, the DOJ won that case, right? Under existing Section 2 doctrine, right? Survived judgment at the DC Circuit, right? Plaintiffs win cases. Happens all the time. Okay? But they've got to have proof of harm to do it. I make that point largely because out of the menu of options that are currently sort of floating around to change modern doctrine, most of them, and they come from left, right, and center. So my friend Senator Hawley has a proposal that would ask my old agency, the Federal Trade Commission, ask political appointees in a bipartisan agency. I've been a libertarian my entire life, not until I was appointed to the Federal Trade Commission did I have to raise my hand and put an R on my chest. Okay? But in that process, you get 5 people who have had to raise their hand and self-identify as an R or a D. You put them in a room and you say, now you guys vote on what political bias is. I can tell you, I've worked at the Federal Trade Commission 4 times. There's not a soul in the building that knows what to do with that or has the expertise to do that. But you've got proposals that would put great amounts of power inside regulatory agencies to shape the experience of citizens on the internet, in apps, sort of in their day-to-day lives. Most of the rest of the antitrust presumptions either are to go back to the 1890 to 1960s vision of antitrust, in which we have 6 goals instead of 1 and no idea how to trade off one versus the other. We have experience with that in this country, and the experience, if you line up antitrust scholars left, right, and center, would largely say wasn't such a good experience. There is proposals to do away with the requirement that plaintiffs demonstrate anti-competitive effect, and instead we do our work through presumption. We go back to counting firms with our fingers, and we say if the market share is above 30, the merger is illegal. Why? Because market share is above 30, and maybe that's bad. Presumptions to do, I picked on Senator Hawley, so we do Senator Warren for the other one. Liz Warren's got a proposal that a couple of people have glommed onto, and I think is making its way into proposed legislation that would ban any of online platforms from doing 2 things at once, sort of no vertical integration. If you are her version of this is something about the umpire and the player, you can't be both at the same time. I've never quite followed the metaphor entirely, but the idea is Amazon can't sell stuff on its own shelves. Any company, I believe it was making over, there was some dollar threshold, so I guess it becomes worse when you're big. Private label grocery stores, private label products in grocery stores would be illegal. Apple sells you all sorts of its own stuff in the Apple Store. I'm pretty sure that would be illegal. Google looked out in the market and said, you know what, the Maps products are really bad. MapQuest, when he used it, it wasn't good. And so Google said, you know what, we're trying. When you type in directions to this place for the conference, people were clicking away from search results because they weren't good, right? They weren't answering the questions that users had, right? And so Google said, I don't know, let's make a better map. So they did, okay? And now you search and they put their own product up. And they probably put their own product up instead of the rival's product, right? They couldn't do that, right? Vertical integration into those spaces would be illegal, per se. Now, under the current antitrust law, I'm not here to tell you those things are always good or always bad, right? Under current doctrine, if you can prove they're bad and done by a monopolist, you got a really good shot of winning your Section 2 case, right? And so I think it's sort of an important thing, and the thought I'll close on, I think is an important thing to have a discussion about presumptions versus proof in existing doctrine. It is a little bit in the weeds of the antitrust law, but it's where all the action is on who wins and loses these cases, and the role of the regulatory state in making these decisions with or without proof being put in front of an Article 3 judge somewhere. So I will end there and look forward to discussion. Thank you.
So thank you all for those remarks. Let's see if you have some reactions to one another's points. I'm sure you sparked a few thoughts.
Sure, I'll start by maybe putting a finer point on why I think we prefer to have antitrust laws rather than, or laws that focus on competitive effects rather than an anti-monopoly law. And for this, I will quote Justice Scalia, who says everything more brilliantly than I could. The mere possession of monopoly power and the concomitant charging of monopoly prices is not only not unlawful, it is an important element of the free market system. The opportunity to charge monopoly prices, at least for a short period, is what attracts business acumen in the first place. It induces risk-taking that produces innovation and economic growth. To safeguard the incentive to innovate, the possession of monopoly power will not be found unlawful unless it is accompanied by an element of anti-competitive conduct. So I think that quote puts into perspective why we ought not overreact and change our system from one that punishes the exercise of monopoly power to harm the competitive process into one that punishes only the exercise of monopoly power to charge higher prices or to act in the market with an effect on consumers. I also want to react to the idea of whether the antitrust laws are up to the task of dealing with a lot of the problems that Barry artfully laid out. I can say with a pretty definitive answer that the antitrust laws are not up to the task of solving every problem that consumers might complain of that a tech platform perpetrates against them. What the consumer laws what the antitrust laws are good at is protecting the ability of consumers to choose. And that means that consumers have to care. That means consumers have to exercise their ability to choose in order to have a beneficial result from that system. So one thing that continually strikes me is that we are talking about privacy a lot in the context of the antitrust debate around the big tech platforms. I think there's a pretty universal belief that there's something about privacy that sort of pulls at our civic duty, our social consciousness, that we all care about the contours of what is expected of companies in protecting our privacy. However, if consumers are not going to exercise the choice to pick between competitors based on their different privacy protections, then the antitrust laws are not a good tool for fixing some of the concerns people have about privacy. So if consumers are over busy or don't understand the privacy protections that are being offered by the different companies, they're not going to be able to benefit from competition between companies offering different levels of privacy. So there's some sort of initial questions that we have to ask about the way the market works, the way consumers respond to different incentives before we can really say whether the antitrust laws are a good tool for solving the social ill that someone has in mind. So it's the antitrust laws are capable, absolutely, of policing the bad behavior of big monopoly companies who would prevent competitors from coming in and competing on the metric of privacy. For instance, there's I see, just as a consumer walking around or as a citizen walking around, I see more and more advertising taking place on the metric of privacy. So it's possible that we as consumers are becoming more savvy. We want this element of our product more than we did 10 years ago, and so companies are responding. They're advertising on it. They're bringing more privacy protections to their products. If that is an element of competition that the consumer cares about, then the antitrust laws are absolutely up to the task of protecting choice, which will then have the salutary benefit of protecting privacy. But we have to do that rigorous work to first understand how the market works, how consumers are responding to incentives before we can really say whether the antitrust laws are a good fit for the things that we're concerned about.
Mr. Lynn.
Yeah, I mean, actually, Taylor helped just by using the word consumer a lot in that last response. The Declaration of Independence, in 2010, folks over at in the archives, they were sort of x-raying the drafts of the Declaration of Independence, and they saw that Thomas Jefferson, when he was writing the Declaration, at one point he scratched out this one word. He just got really, just with real vigor, almost anger, he scratched out this one word. And no one knew what it was until 2010. And they knew what was written on top of it. The word citizen was written on top, but they didn't know what was written underneath. So they finally found out, and it was the word subjects. It was like, we the subjects of the United States, and he scratched out that word subjects, and he wrote on top of it the word citizens. You know, for 200 years, when we looked at our anti-monopoly laws, and the Declaration of Independence was a Declaration of Independence in part from monopolies, such as the British East India Company, we looked at these anti-monopoly laws through as citizens. And what did we want? Did we want cheap stuff? Because arguably the British East India Company was going to deliver us cheap stuff. We don't want cheap stuff. What we wanted was the right as creators, as producers, as people who grow things and make things, as people who think thoughts, to go to a market, and actually to go and exchange directly with our neighbors at market prices that we set ourselves, without any intermediary in between us. So the main thing we wanted was this liberty to engage directly with one another in markets that we control ourselves without intermediaries, and this was something that we saw through the eyes of citizens. A full citizen includes the focus on selling. Now, one of the problems with what happened in the late 70s and early 80s is what happened is, arguably what Robert Bork did is he scratched out that word citizen and he wrote over it the word consumer. Now that may seem like a pretty innocuous thing where, all citizens are consumers, and that's true. But what did we lose in the process? We lost half of ourselves, 3/4 of ourselves, 3/4 of our interest in who we are. But it's also worth actually understanding the origins of the term consumer and the use of the word consumer. If you go back, the word consumer was really first used in a political sense back in the early 20th century by a bunch of folks who were promoting a command and control vision of this country. And they actually saw the word consumer as a way to bring everyone together, to get rid of all the different types of producers who were arguing with each other about access to this market and that market, and creating like a incredibly complex market system. And they said, if we actually get everyone to see themselves as consumers, then we actually get to concentrate power on them. Walter Lippmann, a very famous writer in the 20th century, in 1914 wrote a book. He was like 26 years old, remarkable guy. He became very conservative later. But in 1914, he was a socialist. He was a command and control socialist. He wrote a book called Drift and Mastery. And this is a quote: "Collectivism or state socialism is the chief instrument of the awakened consumer. The task of the progressive elite is therefore the organization and education of the consumer for control." It was a way of using some euphemisms and different frameworks to actually figure out a way to concentrate power, command and control power within the political economy. Now, I don't know, I've had a lot of fights or discussions with my friend Bill Kovacic about this, but were people really aware of what they were doing when they were promoting this consumer welfare frame, when they were getting rid of this idea that we should be looking at our anti-monopoly laws through the eyes of producers, the eyes of makers, the eyes of thinkers? I think, Bill's actually moved a lot on this issue, and I think a lot of you probably know who Bill Kovacic is. He actually, worked at the FTC among many other jobs. But words are important, concepts are important. If you're a subject or a citizen, that's an important thing. If you're a citizen or a consumer, that's an important thing.
Did you have anything you wanted to add?
I'll be brief. I'm going to see if I can use the word consumer without falling into being a socialist. Think I can do it. A couple of things. Two sort of small points that I think are important. One is a response, and another is just, I think, another feature of this discussion that maybe will be helpful for discussion. So one is, when you think about the vision. And I like this sort of subject versus consumer distinction as a lens for this. When you think about what's happened with the consumer welfare standard versus a vision for the antitrust laws that sort of has the antitrust laws to recreate the economy with 6 goals in mind to do a lot of things at once. There are, of course, naturally, when you've got 6 goals, trade-offs between them. Right? And so the question is, if we're doing not just consumer welfare, but consumer welfare and stuff, how much consumer welfare, and I'm an economist at least half the time by trade, so I mean this in the economic sort of sense of the word, the gains from trade accruing to the consumer, right? His willingness to pay for the product versus what he actually pays in the marketplace. So when we do sort of more goals than consumer welfare, like we did from 1890 to 1960 something, how much wealth for consumers are we willing to trade off for those other goals, and what are we getting for it, right? I think that's an incredibly important question. So there are folks that would propose we get out of the consumer welfare standard and sort of do some other things for some other benefits. And they're pretty open, and I think in Barry's answer, I think he's pretty forthright about this. The idea is that we are willing to accept higher prices for individual consumers, and your friendly FTC will decide which consumers will pay higher prices. And I can tell you from being at the FTC, so one of the things that you do is you get emails and calls from people, a lot. Somebody has a bad day at the supermarket, got a bad piece of chicken, they'll call you, okay? It's like half your day, okay? And, I can tell you a lot of those calls are people who care deeply about prices. A lot of those people care deeply about what the price of a gallon of milk is. And so they probably care about other things too. But me and Perry may have time and energy and preferences and tastes and, got a little bit more luxury, degree of freedom to worry about, privacy or other things. But there are a lot of consumers who are primarily interested about price. And I think a fundamental decision is whether we are going to have regulatory bodies make decisions about those trade-offs for them, or whether we're going to have consumers make those decisions for themselves. In markets like these tech platforms that we've been talking about, there's some great economic papers. A guy named Eric Brynolfsson at MIT has done some of these really neat experiments where we tried to answer the question, sort of how much surplus are you getting from the use of your, Gmail, Facebook, pick the platform of your choice, right? And so they do these experiments where they try to elicit valuations for how much consumers would pay to give up the service for a month. And so you get these estimates, right? These are consumers who get dollars and are actually trading in markets, right? And so it's a really clever way to try to get a sense of magnitude of how much consumer value there is there. We're talking about hundreds of billions of dollars in surplus. Right? And I think, as revealed by the actual decisions of consumers, not me and Barry talking about what they should value it as, or maybe they should do something better with their lives than Facebook. Or my mother says that when she sees me tweet, I should do something better than be on Twitter. Right? But revealed preference says, I sort of like Twitter, right? And so the actual decisions of these consumers, citizens, individuals with the sovereign ability to make trade-offs between things they might do with their day suggest a high amount of value. And it gives me great pause to think about bestowing a power to a government agency, even with smart people like Taylor running it, or even if Barry was running it, maybe especially if Barry was running it. He knows I mean well. To give them the power to make those trade-offs instead of individuals and markets gives me great pause, and I think it's something we should be concerned about if we are, as I think Barry and I both are, concerned with individual liberty.
All right. Thank you all. We've saved some time for questions. I think someone got a microphone. My requests are, first of all, that you very briefly at least mention your name, Please try to keep your questions to 3 sentences, and your question should end with a question mark. And I hope that the panelists up here can likewise respond in 2 or 3 sentences so that we can get multiple questions in. All right, you want to pass. Yeah, you start.
Well, thank you, panelists, for just a fascinating discussion. My question is, there are big questions being talked about on this panel. And I wonder, are our laws, our statutes, up to the task of answering them? Or do they provide any meaningful guidance? Because my understanding is, look at the Sherman Act, the Clayton Act, these are vague phrases. And there have been, as you all have identified, massive shifts in judicial doctrine. Is there any meaningful statutory guidance that judges can cling on to? Or are they simply relying on their economic policy visions to make these big decisions that you all talk about?
Anyone have a brief response?
Well, I think there's an important distinction between statutory guidance and judicial precedent embedded in your question. So you're absolutely right that the Sherman Act and the Clayton Act have relatively few words in them, and that a lot of the body of this law has been developed through judicial precedent, and that's why, I think you accurately identify, that's why there has been able to be a shift. But I think that the real hallmark of antitrust law over the ages, as we've discussed up here, is that judges ought to be bound by some measurable goal. Judges and enforcers, I should point out, ought to be bound by some measurable goal of whether the individual who is exercising choice in a market is able to choose between options based on the merits of the different competitors in the market. I think that sort of anchor has been it has been quantified in various different ways over the years. It has been brought into, there have been economic papers and studies that demonstrate the ways in which the consumer is harmed based on certain behaviors or certain concentration or other aspects of market behavior. But I think the real hallmark that has been solidified in the jurisprudence, not in the statute, is that the chooser, if you will, and I'm going to use that word chooser now instead of consumer, because I think that is truly what we mean, is the person or the economic unit, economic actor exercising decision-making authority in the market, that individual is able to benefit by exercising their choice.
Anything quick?
Yeah, I mean, I think it's a great question, and I actually agree with what Taylor and Josh, some of what Taylor and Josh said, that the laws in the way that what Josh and Taylor would be interpreting the laws, there's a lot of power here. I mean, it's like, as was mentioned, Microsoft was, that was a case started in the late 90s, concluded in 2002. And there, there's a lot of, with some more vigorous enforcement, more resources for the enforcers. I think there's a huge amount that can be done without really even taking your glasses off and putting on the other glasses that I, am talking about. But if you change your focus, if you actually say, take off the lens that says this is consumer welfare, and you put on, you say, this is democracy and liberty. We're looking to have democracy and liberty. That's what the purpose of anti-monopoly law is. Then you look at your laws and you see much more powerful laws than you understood, and you see much more clearly how to use them. And and one of the things that you'll see, there's a lot of discussion here between antitrust and anti-monopoly. Now we focus, most of this discussion has been focusing on going back to 1890, going back to the Sherman Act. We don't talk much about 1887, the Interstate Commerce Act. Why don't we talk much about it? Because it was a phenomenal success. It took these institutions that Standard Oil had used. How did Standard Oil become powerful? They leveraged the power of the railroad. How did Carnegie Steel get powerful? They leveraged the power of the railroad, discrimination. How did the railroads themselves get powerful? Through discrimination. Interstate Commerce Act eliminated that. It was one of the greatest victories in American history. The Sherman Act was a failure. Sherman Act resulted almost immediately and it was followed by the most intense period of concentration until most recently in the United States history. It wasn't until the Clayton Act fixed it that actually we had functional antitrust in this country. So, we have all the powers we need. And just another thing is that it's not just the courts and it's not just the enforcers, it's the executive. And just as an example of what I mean by that, 1982, 1984, the guidelines for sort of enforcement of antitrust, those are the ones that sort of we moved to an efficiency test first, and then we replaced the words efficiency test with the words consumer welfare test. And that was done by essentially executive fiat. This is we're going to use the entire executive to enforce this philosophy. So, a different president, and it could be from either party, who used, just put on different glasses, said we're going to do this differently with the executive, you could immediately see a radically different approach across the political economy.
All right, maybe a moderator's prerogative to ask a related question here. When courts developed the consumer welfare standard for evaluating challenges under Section 2 of the Sherman Act, they measured consumer welfare mainly through price and output. But today, many of the tech giants provide their services for free. So how, if at all, should courts rethink the consumer welfare standard? How, if at all, does it apply when the consumer is getting something for free and there's not obvious price discrimination or anything else like that going on?
I'm happy to start. So the consumer welfare standard, when it was, consumer welfare is an economic term referring to the gains of trade from a transaction. And the gains from trade in lots of transactions are easily measured by price and output, right? We now worry a little bit more in these markets, as the question suggests, about harm arising from sort of non-price features. So when I was at the FTC, we had, a dozen cases where the primary theory of harm in the case, Microsoft actually has this feature as well, where the primary theory of harm in the case is not that the monopolist will raise price and reduce output, but rather will harm innovation, right? We have a bunch of discussion about merger policy in the country now that is aimed at the idea that a dominant platform will acquire a small startup and bury the potentially competing innovation in their backyard, never to be seen, right? And so there's lots of discussion where the primary reduction in consumer welfare is felt not by the increase of price, but rather through reduced innovation tomorrow. There is nothing in the legal standard that prevents all those claims. Innovation claims are completely cognizable under the modern standard. The difficulty that arises with them is exactly what you're thinking. It's pretty hard to measure innovation, right? So in the academic world of economists who work on empirical data with innovation, people have been trying to measure innovation and gains to consumers from innovation. We know it's really important. How important? We don't know. People try to measure this stuff. It is still the state of the art in the economics of innovation and IP that people measure innovation with patent citations. Horrible measure, and everybody in the field agrees it's a horrible measure, but it's keys under the lamppost, right? And so the problem when these cases get to court are often when the plaintiff bears the burden of showing proof of the harm and you don't have really good evidence of the harm. We sort of tell stories about why a merger might reduce innovation or might have these harms. So I just sort of want to separate out the points. There is nothing in existing doctrine that prevents agencies or private plaintiffs from bringing those cases, and they do. The FTC has brought plenty. The DOJ has brought cases in this space as well. So as a legal matter, I don't think that there's anything in modern doctrine that needs changing because of the nature and structure of platforms. Those cases, like all sorts of other cases, have practical difficulties when they get to court.
I'll also just add, I agree with everything that Josh just said, but I'll also add that, you know, companies make money. Just because they're selling something just because they're giving something to consumers for free doesn't mean there's not money changing hands somewhere in the system. And a lot of cases, not every case, but a lot of cases that you see in the history of antitrust enforcement involve zero price products on one side of the market, and on the other side there's money changing hands. So we have, you know, a history of merger enforcement at the DOJ in advertising supported media markets, and a lot of the times it's an easy case to explain the effects by looking at the effect of the transaction. Let's say it's a merger case, the effect of the transaction on the competition over advertising dollars. So just because there's a product being offered to consumers for zero price doesn't mean there's not a way to quantify gained monopoly power or harm in the market somewhere else in the sort of full spectrum, full analysis of what's going on in the industry. However, that shouldn't take away from the point that harm to the side of the market that's receiving the good for free can absolutely be measured in quality reduction, right? A price isn't a price in a vacuum. A price is a price for a specific good or service that has a certain amount of quality, so or a certain amount of features. And so one way that consumers can experience harm is by paying more for the exact same amount of quality, but another way they can experience harm is by paying the same for something that has less quality. And so we have the tools in economics to understand what's happening to consumers as a result of changes in conduct or changes in concentration.
I think the Taylor's answer was terrific. It's, there's been a huge amount of movement in this community. It's absolutely in the right direction. And in this debate also. One thing I do think, just sort of looking at like where the debate probably actually does need to go soon, or really needs to go now, is understanding that just the very concept of price in a world that is regulated by Google, Facebook, and Amazon, price is not the same thing that it used to be. When you have first-degree price discrimination, then you actually end up with no price. There is no price out in the market. This is something economists are going to have to face up to. It's something that antitrust enforcers have to face up to. We as the public have to sort of face up to this. When a corporation is selling every one of you the exact same thing but at a different price, or selling you something that's all the same price but with slightly different terms, which means, then there is no price in the marketplace. You actually don't know what the actual price is. You don't know how to measure it. You don't know what it means. Is there too much of it? Is there too little of it? So it's one of the problems with first-degree price discrimination by monopolists. It's one of the reasons that, going back to the beginning of democracy, you have this. We have moved already in many places to a world beyond price.
Questions? Sir. My name is Nick Rotz, and my question is primarily for Mr. Lynn. Based on your concerns that monopolies have the potential to undermine democratic institutions, do you encourage the courts to reconsider the Norr-Pennington doctrine, where potentially anti-competitive conduct is insulated from liability under the antitrust laws?
I didn't actually, it was a little...
I think the question was about whether the Norr-Pennington doctrine ought to be reconsidered because of its connection to democracy.
Well, I don't know if it's not that, I don't think it's an issue. It's not particularly, it's not I think the point I'm trying to really make is that, we should just understand the magnitude of what we face. and that this is something that it's outside of our recent, we've never really seen anything quite like this. I mean, a century ago, the Standard Oil, U.S. Steel did not have spy operations attached to their corporate power. They did not have the ability to engage in first-degree price discrimination, hence manipulation. So yeah, I think that maybe other folks on the platform will want to comment on this, but it's my main point is that we face an imminent and absolute threat to our democracy, in which we have important people, really important people, powerful people, afraid to speak up. And when you have powerful people, influential people afraid to speak up because there's someone over them who will punish them for speaking up, we have no choice but to act.
Next question, Michael O'Connor.
Thank you for a very interesting conversation. I'll try to hew to Judge Bibas's rules, both because of my tremendous respect for him and out of some concern that he might go back and reevaluate my criminal procedure grade. So there's a lot of overlap amongst these big tech companies. They have overlapping boards, their executives attend the same conferences, et cetera, et cetera. And there's at least some evidence that they use that overlap for anti-competitive ends. For example, there was an email between Steve Jobs and Eric Schmidt where they agreed to an employee anti-poaching agreement. So my question is, there's been a lot of talk about Section 2 here, but I haven't heard much talk about Section 1. And I was wondering how the panelists felt Section 1 applied to this area.
No poaching agreements are illegal. I mean, I was being a little bit cheeky, but I think that Section 2 tends to be where the hot topic and debate is. But absolutely, it's true that Section 1 might be a useful tool in these cases if they're ever brought. Section 1 is about agreements between companies, and I think a good case that sort of illustrates how there might be a little bit of overlap in these topics, or how there might be a little bit of overlap between Section 1 and Section 2 is the Amex decision that just recently came out of the Supreme Court. That's a Section 1 case, but it's really all about Amex's decisions about how it was going to interact with the merchants that honor Amex cards. So that case, I think, is a good example of how the topics kind of bleed together at some point when a monopolist is executing contracts which are just agreements with market participants, industry participants, then Section 1 can become involved. If you have any complaints or knowledge you would like to tell me about afterwards about, CEOs discussing illegal things together, please let me know.
I do think and Taylor got that. I mean, we agree completely. I mean, our organization does a lot of work, promoting a strengthening of the enforcement of the law against non-competes and non-poaching agreements, but we fundamentally agree. But what you bring up is actually, it's relevant also to the issue of innovation. I mean, it's what we see is not just that you have these 3 or 4 super corporations that sort of dominate certain technological realms, but the individuals within those corporations actually often sit together in groups that sort of review upstarts, startup companies, and so there's a hierarchy of folks in Silicon Valley who are basically vetting the world of the upstart. If you got an idea, you're going to have to go through a pretty hard cartel of folks in order to get that idea into one of the other of those, to get it to any kind of scale whatsoever.
Hey, I think we got time for one more question. In the back.
What's your name?
Excuse me, Sean Callahan. My question is about applying the common carriage standard to auction-based algorithmic ad targeting platforms, so Google Ads and DoubleClick specifically. I think these companies would say that that without the ability to auction targeted audiences, that both the total number of consumer transactions would go down and the average consumer surplus per transaction would go down. Are they right?
I'm sure they would say that. And our concern as the citizens of the United States are not the well-being of the business models of Google and Facebook. And we will change. We are going to change the business models of Google and Facebook. They will not remain as they are today.
Professor Wright.
Some of you like targeted ads. Some of you get them and you click on them. And that is why you continue to get them. Some of you do not. Markets work this way. Preferences are heterogeneous. Personalized pricing, if my cup of coffee is worth $5 to me, or the market price is $5, what personalized pricing and price discrimination does is there's some consumer who's willing to pay $4 for it, and it costs Starbucks $2 to make. They get it in a market with price discrimination, and they don't otherwise. Starbucks makes more money too, right? But the idea that price discrimination is uniformly bad, one of the obvious implications in the economics of price discrimination is often that lower income consumers do better off, right? Where most of the extraction comes out of is me. They can charge me $20 for this cup of coffee in the morning. I would have paid it and fought the guy in the line in front of me, right? So I get robbed, but the other guy gets a cup of coffee that wasn't going to before because he gets priced into the market. There are complicated trade-offs in the economics of price discrimination, no different and even a little bit more complicated in the sense of personalized advertisements. It is one of the reasons why sort of one-size-fits-all solutions for these business models are likely to end up making a lot of consumers worse off. But there are important trade-offs to think about.
I won't comment on DoubleClick specifically, but I will just address the notion of common carrier type regulation. The basic economic reason to ever engage in that type of regulation would be if there was some reason that multiple competitors couldn't exist in the market, and that reason was beneficial to consumers. So for instance, really strong network effects, or a natural monopoly where your scale has to be so big that there's not room for another competitor in the market. And so in thinking about whether common carrier regulation is ever appropriate, you would ask first whether there's some reason the market can't or shouldn't, for the benefit of us all, have multiple competitors.
But there's a timeline issue on that, because it's like there are many places in which we could have multiple competitors, but we do not now. So the danger is now, and we have to sort of deal with the danger as it exists now.
Please join me in thanking our panelists.